During the middle of a trial, when an attorney gets up to question a witness, is there a difference between asking open-ended questions compared to leading questions? You want to know the answer? Come join me in this walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is yes, there is a significant difference between asking open-ended questions or leading questions, and I'll tell you what they are. All right, first, open-ended questions are simple. They are who, what, where, when, how, why. Questions that call for explanations. Questions that called for detailed answers. Questions that encourage the witness to go ahead and explain. Those are open-ended questions. So why would I ask open-ended questions? I'll tell you why. Because when I call a witness to the stand, whether or not it's the injured patient, the injured plaintiff, the person bringing the lawsuit, or one of our experts, or an eyewitness, someone who actually witnessed the incident, I want the jury to hear from this witness, in his own words, exactly what happened. And the way to do that, the way to encourage the witness to tell the jury exactly what happened in their own words, is by asking open-ended questions. Hey, Mr. Jones, you're standing at the corner of Main Street and First Avenue. Tell me what it was that you saw at the time the light turned green. Oh, let me tell you what I saw. And now he begins to tell the jury in exquisite detail everything that he observed and that he saw. By asking an open-ended question, it gives this witness the opportunity, the ability to go ahead and explain, to tell a story, to tell the jury exactly what he saw and what he heard. Now, that's different than a leading question. A leading question basically makes a statement and asks whether I'm right or wrong. A leading question basically gives the answer in the question. Mr. Jones, isn't it true you were standing on the corner of Main Street and First Avenue? Yes or no. It doesn't require the witness to explain anything. It simply requires him to answer the question in a very simple yes or no fashion. It's either yes, no, I don't know, or I can't answer the question. Mr. Jones, isn't it true that when the light turned green, you were facing the opposite direction? Well, no, that's not true. Okay, let me ask you the next question. There's a big difference between asking a leading question. When I'm asking leading questions, it's typically because the witness is an adverse witness. He's a hostile witness. He's a witness who we believe did something wrong or observed something that we believe was not accurate. So now I want to go ahead and tell the jury a story through our viewpoint. I want to see if this witness agrees with our viewpoint. And how do I do that? Mr. Jones, isn't it true you have difficulty with your hearing? Yes, it is. And isn't it true that as you stood on that corner of Main and First, that it was nighttime? Isn't that true? Yes. And isn't it also true when you went out that night to go get a newspaper, you forgot to put in your hearing aid? Isn't that true? Yes. And isn't it also true that you wear eyeglasses? Yes? Yes. And you wear eyeglasses to see far distances. Isn't that true? Yes. And that night, when you went out to get that newspaper, you didn't put on your eyeglasses, did you? No, I didn't. So not only did you not have your hearing aid in, but you didn't have your eyeglasses. Is that correct? Yes. So these questions call only for yes or no answers. And why am I doing that? Because I want to show the jury that this witness's version of the events that he observed and heard are not accurate. And the way to do that is with leading questions. By showing him that we have information that contradicts his story, I can now use a leading question to go ahead and elicit an answer that he either agrees with my question or disagrees. He could disagree all he wants, but as long as I have confirmation, as long as I have other information to show that this guy did not hear accurately and did not see accurately, great, then my leading questions will establish or show to the jury that his version of the events are significantly different and contradict the evidence that we have put forth. And ultimately, it will be up to the jury to decide who is more believable. Is it this witness? Is it our witnesses? Is it our evidence? And the jury will ultimately make that decision. But by asking leading questions, now I have the ability to control the conversation. I am the one to decide what topics and what questions to ask. And now I'm not giving this witness free rein to go ahead and talk. He will be able to do that. He'll be able to give as many answers as he wants when the opposing lawyer gets up to question him and says, hey, Mr. Jones, tell me what it is that you saw. Tell me why you heard exactly what you heard. Tell me how you were able to visualize, if you didn't have your glasses on, why you saw what you saw. And now he's going to explain away those answers. But if it's my witness, I'm going to go ahead and give him every opportunity to explain what happened in as much detail as possible. Hey, Mr. Gold, go ahead and tell the jury exactly what you saw. Explain to them what was going in your mind at the time that you saw my client, the injured victim here, go flying through the air as she was hit by this car. Tell them what you observed. And now he's going to go ahead and explain. Asking a leading question is most often done to lead the witness, really, to lead the witness, to almost put words in the witness's mouth and get them to agree or disagree. Okay? That's the goal. If I can achieve that, then now I'm ahead of the game. If I can't, then in all likelihood, these witnesses, these opposing witnesses, often are not gullible, and I'm not trying to trick anybody, but they will often argue. They will get into semantics about the meaning of certain words. So we try and control the conversation. Mr. Jones, I'm going to be asking you a series of questions that simply call for a yes or no answer. If you can answer that yes or no, do you agree to answer only yes or no? Yes. If you don't know the answer, instead of giving me an explanation, do you agree to simply tell me you don't know the answer? Yes. If he doesn't, if he fights with me on that, now he's going to look silly and foolish in front of the jury. Mr. Jones, if you cannot answer my question, do you promise to tell me that? Yes, I do. Without giving me an explanation about why you can't answer it? Yes. And if you can't answer it, I promise to ask you a different question. Is that okay? Yes, it is. So what am I doing? I am now laying some ground rules for my questioning of this witness, and now I will ask him leading questions. So why do I share this with you? I share this with you because when you walk into a courtroom and now you see a witness up on the stand being questioned by an attorney, listen for a few moments to the type of question that is being asked. Is it an open-ended question that calls for details and an explanation, or is it a question that calls only for a yes or no answer? That will tell you whether it's either a leading question and whether this witness is opposing what this lawyer is trying to prove, or is it his own witness and now he's trying to get information in front of the jury. You know, I recognize you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a fantastic day.